Chapter 25, Consumer Law, presented by Kelly Herzik. In this lesson, we will discuss the Federal Trade Commission, deceptive advertising, labeling and packaging laws, sales, credit protection, and consumer health and safety. We will begin with a key federal agency that regulates and enforces consumer statutes, as well as issues regulations designed to protect consumers, the Federal Trade Commission, the FTC. The role of the FTC is primarily to enforce civil U.S. antitrust laws and to protect consumers. We will be focusing on the FTC's mission of consumer protection in this chapter. However, it's important to note that in 2010, Congress enacted the Dodd-Frank Wall Street Reform and Consumer Protection Act. Among other things, Dodd-Frank established the Consumer Financial Protection Bureau, the CFPB, with the authority to supervise and regulate entities that offer or provide consumer financial products or services. The CFPB enforces over a dozen consumer financial protection laws, including the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, and the Truth in Lending Act. In addition, the CFPB has the power to stop practices that are unfair, deceptive, or abusive. The FTC shares authority with the CFPB to enforce the consumer protection laws with respect to non-bank financial institutions. For some reason, your book does not mention the CFPB, which is odd because it was created in 2010. But if there is a conflict with the book and the slides, use the slides because it's the most updated information. The Federal Trade Commission, the FTC, was created through the Federal Trade Commission Act of 1914. The FTC is an independent federal agency with 5 commissioners appointed by the President and confirmed by the Senate. Each commissioner serves for a 7-year term, with 1 commissioner selected by the President to serve as the chairperson. The FTC's goal of protecting consumers is accomplished through 2 methods: consumer education and legal action. The FTC creates campaigns to educate consumers about the laws that protect them and also educates businesses on how to voluntarily comply with the laws. The FTC also issues industry guidelines which contain FTC interpretation of existing consumer laws to encourage businesses to cease unlawful actions. Next, we will discuss FTC actions. When a consumer files a complaint, if the FTC has jurisdiction and not the CFPB, it will review the complaint and can open a non-public investigation into the company at issue. The FTC accepts consumer complaints concerning identity theft, the National Do Not Call Registry and registry violations, computers, the internet and online privacy, some telemarketing scams, some credit scams, immigration services, sweepstakes, lotteries and prizes, and business opportunities and work-at-home scams. The FTC does not resolve individual consumer complaints. It does not prosecute criminal violations. Those are referred to DOJ for action. If an investigation is opened and the FTC determines that the company violated the law, the FTC will send a complaint to the alleged violator. At that point, the FTC and the company may resolve the issue through a consent order, which is a signed statement that the company agrees to cease the alleged violations but does not admit that it broke the law. If a company does not abide by the consent order, there are usually monetary penalties, fines up to $10,000 per violation that are imposed and could lead to further adverse action by the FTC. If there is not a consent order, or a consent order is violated, the FTC may decide to issue a formal administrative complaint, which will lead to a hearing before an administrative law judge. If the administrative law judge finds that the company violated the law, the FTC will issue a cease and desist order requiring the company to stop the illegal behavior. The FTC may also issue multiple product orders, which is a form of cease and desist order that applies not only to a specified product, but also other products produced by the same company. The FTC can also order corrective advertising. The company will be required to run ads that explicitly states that the former advertised claims were untrue. These corrective advertising orders are controversial. Companies claim that they're a form of compelled speech and violate the First Amendment right to engage in free speech. If the company does not believe it violated the law, it has appeal rights to the 5 commissioners at the FTC. If the commissioners uphold the ruling, the company can appeal to the U.S. Court of Appeals with jurisdiction over the state where the company resides or does business, or where the alleged action occurred, and ultimately to the U.S. Supreme Court if it will grant cert and accept the case. In addition to administrative action, the FTC can also file suit in federal district court to seek injunctive relief from the company, such as rescission or reformation of contracts, restitution, refund of monies paid, and disgorgement of ill-gotten monies pursuant to the FTC Act. The FTC can also seek civil penalties in federal court for up to $10,000 per violation. Next, we will discuss deceptive advertising. Section 5 of the FTC Act prohibits deceptive and unfair acts in commercial settings, including consumer purchases. Deceptive advertising is regulated under this section. Deceptive advertising occurs when advertising is done with claims that mislead or could mislead a reasonable consumer. Puffing, which is the use of generalities and clear exaggerations, is permissible. While the FTC decides whether an advertisement is deceptive on a case-by-case basis, deceptive claims generally have 3 elements: a material misrepresentation or omission or practice that is likely to mislead a reasonable consumer. If an advertisement is a half-truth, information that is true but not complete, this is deceptive advertisement. To combat deceptive advertising and half-truths, the FTC requires ad substantiation, which requires advertisers to have a reasonable basis for claims made in their ads. The FTC also issues guides on different prohibited advertising practices, such as bait-and-switch advertising, to assist businesses and consumers. Bait-and-switch advertising involves advertising a lower-priced product, the bait, but then steering the consumer to purchase a higher-priced product, which is the switch. Private companies and individuals can also seek injunctive relief and damages against businesses for deceptive advertising based on a private right of action under the Lanham Act, which in part was intended to protect persons in commerce from false advertising and unfair competition. However, there's no private cause of action under the FTC Act. Only the FTC can sue under the FTC Act. Next, we will discuss telemarketing and electronic advertising. 2 major federal acts regulate telemarketing by phone, fax, and text. The Telephone Consumer Protection Act, the TCPA of 1991, and the Telemarketing and Consumer Fraud and Abuse Prevention Act of 1994. The Federal Communications Commission, the FCC, enforces the TCPA. The TCPA forbids cell phone solicitation using an automatic telephone dialing system or artificial or pre-recorded voice. Telemarketers cannot use an artificial or pre-recorded voice on landline calls, although they can use an automatic dialer. In 2012, the FCC revised its TCPA rules to require telemarketers to obtain prior express written consent from consumers before robocalling them, to no longer allow telemarketers to use an established business relationship to avoid getting consent from consumers when calling their home phones, and to require telemarketers to provide an automated interactive opt-out mechanism during each robocall so consumers can immediately tell the telemarketers to stop calling. The TCPA also forbids advertisements via fax unless the recipient consents to the fax transmission. Businesses must obtain written consent from individuals before sending them any text messages. Now, consumers who sue under the TCPA for violations of the statute, the consumer can recover from $500 to $1,500 per call, with the highest fine for intentional violations of the statute. While there are no caps on damages under the TCPA, the consumer cannot get attorney's fees. I don't think that upsets the consumers much because I've been involved in several cases where there were so many calls that the fine ended up being over several $100,000. The FTC, in conjunction with the FCC, oversees the National Do Not Call Registry, and it accepts registration from both landlines and cell phones. After 30 days from the date of registration, telemarketers generally must stop unsolicited telemarketing calls. It's very easy to put your number on the Do Not Call list. You can do it right online from the FTC website. Under the TCPA, remember, it's unlawful for any person to make any call other than a call made for emergency purposes or made with express prior consent using any automatic telephone dialing system or any artificial or pre-recorded voice message to wireless numbers. Now, this law applies regardless of whether the number is listed on the National Do Not Call list. So both the TCPA and the Do Not Call list limit telemarketing calls each in their own way. The Telemarketing and Consumer Fraud and Abuse Prevention Act is a federal law aimed at protecting consumers from telemarketing, deception, and abuse. For example, the FTC requires sellers making telemarketing calls to specifically identify themselves and the product they are selling. In addition, callers cannot use obscene or abusive language, and it cannot call before 8 a.m. or after 9 p.m. in any time zone. The Act expanded controls over telemarketing and gave more control to prescribe rules to the FCC, which enforces the Act. Next, we will discuss data mining and privacy. There is a huge amount of electronic data generated in conjunction with electronic communications and internet use. The federal government wants access to this data for national security, while private businesses want access for enhanced marketing and sales to consumers. This is known as data mining. Data mining is the process of finding anomalies, patterns, and correlations within large data sets to predict outcomes, to increase revenues, cut costs, improve customer relationships, or reduce risks. Most consumers see data mining as an invasion of privacy. The FCC has an important role in regulating data mining and consumer privacy, though the Trump administration has repealed rules established by the FCC concerning internet privacy. Next, we will discuss labeling and packaging laws. Labeling and packaging of products can influence consumer purchases, but can also lead to misleading information provided to consumers based on what is on the label. Both federal and state laws govern and regulate product labeling and packaging, and generally require a manufacturer to provide accurate, understandable information, and in the case of potentially harmful products, must make the consumer aware of the harm. The Fair Packaging and Labeling Act governs food labels that require specific information about the product, its ingredients, the quantity included in the package, the size of a serving and the number of servings, and the nutritional content. The Nutritional Labeling and Education Act of 1990 requires standard nutritional information like calories, vitamins, and fat, and governs such words like fresh and light and low fat. The FTC has restricted these words to prevent deceptive advertisement. Next, we will discuss sales, specifically door-to-door sales and in-home sales. The FTC and the CFPB and other government agencies regulate consumer sales. Now, most of the things I'm going to talk about in this slide, the next few slides, are actually FTC rules, but the CFPB, since its creation, has also enforced these FTC rules. So when I talk about these rules, there's actually a dual enforcement by the FTC and the CFPB. There are some sales in which consumers are considered more vulnerable than in normal retail sales. So the FTC has issued rules designed to protect consumers in these situations: door-to-door sales, telephone sales, and mail order sales. We'll start with the door-to-door sales. In most door-to-door sales, the consumer does not have a chance to compare products or services to find the best deal for their money. Plus, many consumers find it difficult to escape or turn down a salesperson in their own home. The FTC created the cooling off rule to combat the inherent problems in door-to-door or in-home sales, and this gives consumers 3 days to cancel purchases made in their own homes. Consumers must be notified both verbally and in writing of their right to cancel, and the written notice must be in the same language as the verbal notice to protect non-English speakers. Next, we will discuss telephone and mail order sales. According to the FTC, telephone and mail order sales generate more complaints than door-to-door sales or traditional retail sales. The FTC originally addressed these problems with mail order sales in 1975 with the mail order rule. It was amended in 1993 by the Mail or Telephone Merchandise Order Rule. Now, this rule is also enforced by the CFPB. This rule extends protections to consumers who buy products over phone lines, including through computers online and fax machines. Under the rule as amended, sellers must ship items within the time promised, or if no time is specified, within 30 days of receipt of the order. If the seller cannot ship within the required time, the seller must give notice in writing and give the customer an opportunity to cancel the sale. If the customer elects to cancel the sale, the seller must promptly return the customer's money within a specified time period, usually 7 business days. Under the Postal Reorganization Act of 1970, anyone who receives unsolicited merchandise sent via the mail can keep it. They are free to keep it with no obligation to pay for it. It's treated as a gift. Next, we'll discuss FTC regulation of sales in specific industries. There are certain industries in which sellers have extensive opportunities to take advantage of consumers. So the FTC and Congress created rules for certain sales practices in specific industries. We'll begin with used car sales. Consumers who buy used cars often have limited information concerning the condition of a car or its history, such as a past accident, though the internet has somewhat ameliorated that. The Odometer Act of 1973 protects against odometer fraud in used car sales. That's just the rolling back of the odometer. The act was extended in 1984 through the FTC's Used Motor Vehicle Registration Rule. Under this rule, a used car seller must attach a buyer's guide label on any used car for sale. The label must state that the car is being sold as is, warning the customer that the seller makes no guarantees about the car's performance and that the buyer should have the car independently inspected prior to purchase. State laws concerning protections for used car sales, known as lemon laws, vary state to state. The Kansas lemon law applies to the purchase or lease of new motor vehicles under 12,000 pounds. It also promotes a procedure to follow and a remedy if a Kansas consumer's vehicle qualifies as a lemon under the law. Unfortunately, it does not apply to used cars. The FTC also regulates funeral home services. To prevent funeral homes from taking advantage of grieving customers, the FTC created the Funeral Rule, most recently revised in 1994. The rule requires funeral home operators to provide customers with itemized price information about funeral goods and services. Funeral homes may not misrepresent legal or cemetery requirements or require customers to buy certain funeral goods or services as a condition to receiving other funeral goods or services. Then there are real estate sales. Congress has passed several statutes requiring sellers to disclose certain information about the property. There is the Interstate Land Sales Full Disclosure Act of 1968. Anyone planning to sell or lease 100 or more lots of unimproved land through a common promotional plan, usually a subdivision, must file an initial statement of record with the Department of Housing and Urban Development's Office of Interstate Land Sales Registration. Before the developer can offer any of the lots for sale, HUD must approve the initial statement. Congress provided important protections to consumers in home purchases under the Real Estate Settlement and Procedures Act, RESPA. RESPA requires lenders to give buyers and sellers an estimate of the final cost to close a home loan on 1 to 4 family residential properties. RESPA was also introduced to eliminate abusive practices in the real estate settlement process, to prohibit kickbacks, and to limit the use of escrow accounts. RESPA also restricts sellers from mandating the use of a specific title insurance company. Currently, the Consumer Financial Protection Bureau, the CFPB, administers the Truth in Lending Act / Real Estate Settlement and Procedures Act, the TILA-RESPA Integrated Disclosure Rules, known as TRID, which is a mouthful, also known as the Know Before You Owe rule. This provides the RESPA disclosures of the final settlement cost in one larger disclosure that also includes the required TILA disclosures. It's called the TRID. Then there are online sales. The FTC and the CFPB prosecute online fraud under existing wire fraud prevention statutes. Wire fraud is also a crime under 18 U.S.C. Section 1343. The widespread use of credit to make purchases means that consumer credit protection has become increasingly important. We will discuss 3 key federal statutes regulating the credit industry that protects consumers. The first is the Truth in Lending Act. One of the earliest and still significant federal statutes regulating consumer credit is Title I of the Consumer Credit Protection Act, which is universally known as the Truth in Lending Act, TILA, of 1968. The goal of TILA is to promote the informed use of consumer credit by requiring disclosures about its terms and costs, and to standardize the way costs associated with borrowing are calculated and disclosed. Prior to July 21, 2011, the Federal Reserve Board administered TILA requirements through Regulation Z. However, as a result of the 2010 Dodd-Frank Act, TILA's rulemaking authority was transferred to the Consumer Financial Protection Bureau, the CFPB, which most recently revised Regulation Z in April of 2019. The CFPB describes Regulation Z as protection for people when they use consumer credit. Although the Dodd-Frank Act generally transferred rulemaking authority under the Truth in Lending Act and the Consumer Leasing Act to the CFPB, the Federal Reserve Board retains authority to issue rules for certain motor vehicle dealers under Regulation M. TILA applies to individual consumer loans only, those for personal, family, or household use. It does not apply to business, agricultural, commercial, or organizational loans. TILA applies to those who lend money or arrange for credit in the ordinary course of their business. TILA applies when the credit is subject to a finance charge or is payable by a written agreement in more than 4 installments. If a credit card is involved, however, certain provisions apply even if the credit is not subject to a finance charge or is not payable by a written agreement in more than 4 installments, or if the credit card is to be used for business purposes. TILA does not apply to credit transactions in excess of an annually adjusted threshold, not secured by personal property or real estate used or expected to be used as a principal dwelling. For 2020, that amount is $58,300. Private educational loans and loans secured by real property, such as mortgages, are subject to TILA regardless of the amount of the loan. TILA generally covers 3 major types of credit: open-ended credit, closed-end credit, and credit card applications and solicitations. There are also rules covering certain student loans and credit cards offered to students. Each category has specific disclosure requirements. Open-ended credit involves home equity lines of credit and credit cards. These types of credit lines permit repeated transactions and charge interest on the unpaid balance, and creditors are required to disclose information in periodic statements, usually monthly. Closed-end credit involves most mortgages and motor vehicle loans with fixed loan terms for a specific amount of time. Mortgages are usually 15 or 30 years, and car loans generally run from 48 to 60 months on average. Creditors must disclose the total amount financed and the number, amount, and dates of payments. Credit card applications and solicitations must disclose the annual percentage rate, the APR, annual fees, and grace period for paying without a finance charge. TILA contains certain protections for consumers, especially with credit cards and home loans. TILA establishes certain consumer protection rules regarding unauthorized charges to credit cards. If unauthorized charges are made and prompt notice is given of the disputed charge, the consumer is liable for only $50 of the loss. And if no charges are made before notice of the theft of the card, the consumer generally has no liability. Consumers are also protected if goods purchased are damaged or do not arrive. There are many protections provided during a mortgage loan, but one of the most important is the right to cancel refinance loans with their home as collateral. The consumer must be given notice of their right to cancel the transaction within 3 business days from the date of closing and how to accomplish any rescission of the loan if they change their minds. Now, this does not apply to the initial purchase of the home, the purchase money loan. Next, we will discuss 2 additional consumer protection statutes, the Consumer Leasing Act and the Equal Credit Opportunity Act. TILA was amended in 1988 by the Consumer Leasing Act. This act regulates personal property leases that exceed 4 months in duration and that are made to consumers for personal, family, or household purposes. The total contractual obligation cannot exceed $58,300 in 2020, which is adjusted annually by the CFPB. It applies to creditors who lease goods as a regular part of their business. The Act requires that certain lease costs and terms be disclosed. It imposes limitations on the size of penalties for delinquency or default and on the size of residual liabilities, and requires certain disclosures in lease advertising. Then there's the Equal Credit Opportunity Act of 1974, which also amended TILA. It was passed by Congress to address discrimination in lending. Creditors are prohibited from denying credit to an individual based on race, religion, national origin, color, sex, marital status, or age. When determining creditworthiness, marital status must be ignored, and a spouse cannot be required to co-sign a loan. The Act also prohibits creditors from denying credit based on whether the applicant receives public assistance benefits. Next, we will discuss the Fair Credit Reporting Act. The Fair Credit Reporting Act, the FCRA, was enacted to promote the accuracy, fairness, and privacy of consumer information contained in the files of consumer reporting agencies. Generally, it governs how creditors may make notations on a consumer's credit report and how credit reporting agencies may maintain such information. Credit reporting must be accurate. Creditors and credit reporting agencies have a duty to ensure credit reporting is accurate and not incorrect or obsolete, which is older than 7 years, except for bankruptcies, which can be on the report for up to 10 years. If creditors discover that any reporting is inaccurate or complete, they must correct it. Credit reporting agencies also have a duty to correct inaccurate, incomplete, or unverifiable information within 30 days, though they can continue reporting verified, accurate information. Consumers have several important rights under the FCRA. A consumer is entitled to know if information in their credit report has been used against them to deny credit, insurance, employment, or any other adverse action, such as a denial of a lease. The person taking adverse action due to credit reporting information must tell the consumer and give them the name, address, and phone number of the agency. Consumers are entitled to know what's in their credit report and can request a free copy every 12 months. Consumers have a right to request their credit score. Consumers have the right to dispute information on their credit report with the credit reporting agency, and the agency must investigate and correct any inaccurate information within 30 days, though they do not have to investigate frivolous claims. These claims have to be in writing. That's what triggers the need to investigate with the credit reporting agency. Consumers can sue credit reporting agencies, and in some cases, providers of information like creditors and users of information like lenders, though there are some statutory procedures and conditions precedent for that to happen. They can sue for violations of the FCRA in state or federal court to recover actual and statutory damages and attorney's fees. Access to credit reports is limited to those with a valid need, usually those considering applications for credit, insurance, housing, or employment. Though in the case of employment, a consumer must give express written permission for the information to be released. These are the major rights, but it's not a complete list. Identity theft victims and military personnel have additional protections. Consumers can also put a security freeze on the credit report held by the major credit reporting agencies, meaning no release of information without the consumer's express permission, though this could delay credit decisions. Consumers can also put a free one-year fraud alert on their credit report, which requires creditors and other businesses to verify the consumer's identity before taking credit or other action. Identity theft victims get a 7-year fraud alert. Next, we will discuss the Fair Debt Collection Practices Act. The Fair Debt Collection Practices Act, the FDCPA, was passed in 1977 and provides legal protection for consumers from abusive, deceptive, and unfair debt collection practices. The FDCPA applies only to debt collectors who regularly attempt to collect debts on behalf of others. It does not apply to a creditor collecting on its own debt. Who qualifies as a debt collector has been heavily litigated under the Act. It can include attorneys and mortgage loan servicers who begin servicing a loan if the loan is in default already, or one who buys defaulted debts for the purpose of collecting on them. The FDCPA applies only to consumer debts for personal, family, or household purposes, such as credit card debt, auto loans, medical bills, student loans, mortgages, and other household debts. Business debts are not covered. Debt collectors are required to do certain things in debt collection and are prohibited from engaging in other practices. The next 2 slides I've laid out what debt collector conduct is prohibited and what is required. So on this first slide, we'll do some prohibited actions and then we'll go to required actions, the same on the next slide. So for prohibited actions, they cannot contact a debtor at work if the employer objects. They cannot contact the debtor who has notified the collector that they want no contact with the agency. They cannot contact the debtor before 8 a.m. or after 9 p.m. in their time zone. And they cannot contact third parties about the debt except a spouse, the debtor's parents, or financial advisor. So what are some of the things that they're required to do? Well, they have to identify themselves and notify the consumer in every communication that the communication is from a debt collector, and in the initial communication that any information obtained will be used to effect collection of the debt. This is the mini Miranda warning. They must also give the name and address of the original creditor within 30 days from a written request from the debtor, and they must notify the consumer of their right to dispute the debt. There are some more prohibited actions for debt collectors. They cannot use obscene or threatening language when contacting a debtor. They cannot misrepresent the collector's identity, such as claiming to be a police officer or lawyer, or threatening arrest or legal action that is not allowed or not even contemplated. They cannot use the telephone to harass and repeatedly call the debtor to make it ring over and over and over again. They cannot contact a consumer who is known to be represented by an attorney, nor can they misrepresent the amount of the debt. They are required to provide a verification of the debt to consumers who dispute the debt or who request verification of the debt within 30 days of a written request. Collectors must also file any lawsuit in the proper venue where the debtor lives or signed the contract. The CFPB enforces the FDCPA, though it used to be the FTC prior to the Dodd-Frank Act. Courts generally use the least sophisticated consumer standard in determining the scope of the FDCPA, meaning courts will generally hold that debt collector conduct is governed by the FDCPA if the least sophisticated consumer would be deceived or misled by the conduct or find it unfair or unconscionable. Consumers have a private cause of action under the FDCPA. Any action must be filed within 1 year of the date of the violation, not from when you find out about the violation, but from the date of the actual violation. Aggrieved consumers may recover damages. They may recover actual and statutory damages, attorney's fees, and court costs from third-party debt collectors. The FDCPA is a strict liability law, which means that a consumer need not prove actual damages in order to claim statutory damages of up to $1,000 per case, plus attorney's fees. The collector may, however, escape penalty if it shows that the violation was unintentional and the result of a bona fide error that occurred despite procedures designed to avoid the error at issue. Statutory damages in an individual case are $1,000 per case, not per violation, and it's plus attorney's fees and costs. It's the same under the FCRA, statutory damages of $1,000 per case. Class actions under these statutes have different rules and caps. Next, we will discuss the Fair and Accurate Credit Transactions Act. The Fair and Accurate Credit Transactions Act, FACTA, of 2003 amended the Fair Credit Reporting Act and was passed in response to the growing number of identity theft cases. Anyone who is the victim of identity theft may contact the FTC and an alert will be placed on their credit report. These alerts serve as a national fraud alert system that assists law enforcement in catching identity thieves. They're called red alerts. The Act allows consumers to obtain a free credit report every 12 months. The three major credit reporting agencies are Experian, Equifax, and TransUnion. To obtain a free credit report, consumers can go to annualcreditreport.com, which is the official website to obtain a free credit report under the Act. On receipts for purchases, the full credit card number cannot be printed to better protect consumers. Financial institutions must work with the FTC to red flag any suspicious transactions that might be a sign of identity theft. Victims of identity theft are given assistance and can report the identity theft and fraud directly to credit reporting agencies to help protect their credit scores. Next, we will discuss the Credit Card Act. The Credit Card Act of 2009, also known as the Credit Card Holders Bill of Rights Act, was passed in 2009 and was intended to establish fair and transparent practices relating to the extension of credit under an open-ended credit plan, such as a credit card. Its purpose was to curtail deceptive and abusive practices by credit card issuers, and it aims to eliminate or lower certain credit card charges, minimize manipulation of younger consumers, and provide greater disclosure of fees to all users. The CFPB is the agency tasked with developing, implementing, and enforcing the rules necessary for compliance by card issuers. The Card Act includes a wide range of consumer protections, mostly related to interest rates and how they're calculated, fees, disclosures, and marketing towards young adults, college-age students. The Card Act has several provisions that provide key protections for consumers. Creditors are required to notify consumers of changes to fees and interest rates going forward before the changes take place. The notice must be given 45 days in advance. Credit card statements must display whether and when interest rates will increase and must give notice of payoff timing, meaning how long it will take to pay off with minimum payments only. Notice must be given upfront about the date a payment is considered late and what the late fee amount is, generally capped at $25, though it can go up for repeated late payments. Credit card issuers must calculate interest based on an account's average daily balance during just the previous billing cycle. Interest rate hikes on existing balances are largely prohibited, except in instances where the rates vary with the prime rate, penalty rates are charged for late payments, or the promotional rates expire. But the law allows consumers to opt out of any changes made to their credit card and lets them pay off the existing balance under the previous terms over as long as 5 years. Card issuers have to give consumers at least 21 days to make payments after their statement closes. The due date has to be on the same day of the month, every month, and payments received before 5 p.m. on the due date must be credited to the account on that day. Credit card companies cannot extend credit to anyone under 21 unless someone else with sufficient incomes co-signs, and they cannot use tangible items to entice college-age consumers to enter into credit card agreements. The Act also banned a practice called universal default, in which a credit card issuer raised interest rates in response to a late payment reported by an unrelated creditor. However, the law does not cover everything. The law doesn't impose an overall cap on interest rates, so card issuers are free to charge rates as high as the market will bear. Also, small business cards are exempt from many of the provisions of the Card Act, although many card issuers voluntarily have their small business cards comply with most of the protections afforded to consumer credit cards. Now, there is one other area that's protected by the Card Act, and that's gift cards. Gift cards must last for at least 5 years, and practices such as hidden declining balances and hidden fees for cards not used in a reasonable time are prohibited. There are a couple of other consumer protection acts worth mentioning. One is the Credit Card Fraud Act, which was passed in 1984. It was designed to close loopholes in other federal laws that allowed credit card fraud to be pervasive. It increased the penalties for credit card fraud. Under the Act, it's unlawful to possess an unauthorized credit card, counterfeit or alter a credit card, use the account number of another's card to commit fraud, and use a credit card obtained from a third party with consent, even if they conspire with you to report the card as stolen. Then there's the Fair Billing Act. It was passed in 1986 and was designed to handle credit card billing errors. The Act created procedures for consumers to follow in reporting billing errors to credit card companies and created a complaint process consumers could use to file complaints with the FTC. The Act requires credit card companies to respond to the complaint, explain the billing error, and fix the error if necessary. The creditor cannot collect on the disputed debt or take any action until the complaint process is completed. We will end Chapter 25, which is also the last chapter in your textbook, with Consumer Health and Safety Acts. Now, Exhibit 25-3 names some other consumer protection and health and safety laws. I will give you a hint. The only ones you need to worry about are on this slide. The first is the Federal Food, Drug, and Cosmetic Act of 1938. It was last amended in 1997. It protects consumers from misbranded or adulterated food, drugs, medical devices, or cosmetics. The Act is administered by the U.S. Food and Drug Administration, the FDA. The FDA must ensure food, drugs, medical devices, and cosmetics meet specific safety standards. The FDA must follow set procedures to determine whether a drug is safe to enter the market. Drug reviews are generally for 15 months, but there is an accelerated review process for new important drugs, and the Act also allows patients to access experimental drugs. Then there is the Consumer Product Safety Act of 1972. It created the Consumer Product Safety Commission, the CPSC, whose purpose is to protect the public against unreasonable risks of injuries and deaths from consumer products. The CPSC issues and enforces mandatory standards regarding product safety and works with industry to develop voluntary product safety standards. The CPSC can order a recall, or it can work with industry on a voluntary recall of unsafe products. It can also ban unsafe products completely from the market. It conducts research on hazardous products. And finally, the CPSC educates consumers about product safety. This is the end of Chapter 25.